Hello, cannabis community. My name is Kristina Munsters, and I'm here to talk to you about everyone's least favorite topic, responding to a formal complaint from the CRA. Specifically, we're going to be talking about making a request for a compliance conference. We'll go over the basics of that. This video is geared towards cannabis license holders who are experiencing a formal complaint for the first time, but I'm hoping that anybody who is going through this process will find this video helpful. To back up a little bit, I am a litigation partner here at Warner Norcross & Judd. I practice business litigation, which means that I help businesses go through disputes and the court process. Part of that practice is serving the cannabis industry. And in that respect, I serve on the Cannabis Law Council for the state of Michigan, which is a group of lawyers that like to talk to the CRA about issues facing the cannabis industry and educating others on cannabis law. So we're going to be talking about the who, what, when, where, why, and how of a compliance conference. We'll start with the what because you need to know what it is before we get into the rest of it. So what is a compliance conference? It is an informal meeting between the license holder and the CRA that is an opportunity to try and resolve the formal complaint without going through the entire litigation process. So if you don't request a compliance conference, the next step is for the formal complaint to be kicked over to the Attorney General's office to be prosecuted in front of an ALJ. The compliance conference is a step before that where you have the opportunity to meet with CRA, show mitigating information, discuss the allegations in the complaint, and try to come to a resolution without going through that whole litigation process. So what you do at the compliance conference is you present information to show if there's any factual disputes, maybe the allegations in the complaint are inaccurate and you want to show the CRA some factual information to show those inaccuracies, or it's an opportunity to show mitigating information, which is information that would show the CRA that you've come into compliance, it won't happen again in the future, and reasons for the fine to be lowered, or maybe even for the formal complaint to be withdrawn if you can show them that there really wasn't anything that happened that was against the law. So who is involved in the compliance conference? There will be somebody on behalf of the license holder that will either be the decision maker, for example, the manager of the LLC or someone else with decision-making authority. And sometimes also you might want to have somebody who is familiar with the facts of the particular situation in order to respond to any questions the CRA analyst might have that the decision maker might not know the details of. So for example, if the compliance conference is about an AFS report that didn't get filed, you may want to have the accountant there as well if they're available to talk about where in the process they are. Also, the licensee can have their attorney who is representing them in the compliance conference participate. You don't necessarily need an attorney to be with you at the compliance conference, but it can be helpful to have an attorney represent you in order to explain to you strategy for how to interact with the CRA, information that would be helpful to present to the CRA, and help with answering the questions that the CRA might have for you at the compliance conference. Also participating on behalf of the CRA will be the CRA analyst who's assigned to your case. This will be the person who the CRA has tasked with interacting with the license holder to try and get this resolved. That person will analyze any mitigating information that you submit to them and then make a recommendation to management on how the complaint should be resolved, if they're going to make a settlement proposal or withdraw the formal complaint and try and resolve it on behalf of the CRA. When does the compliance conference happen? Well, the formal complaint will tell you you need to request it within 21 days of receiving the formal complaint. That is important. So you need to request it in writing within those 21 days. It can be by emailing the CRA analyst whose email is listed in the formal complaint, or by writing a letter, but frequently we do it by email. And once you request that formal complaint, the CRA will schedule it for about a month out from the date that you request it. It depends on their caseload though. So if the CRA is facing a lot of enforcement proceedings, then it could be a few months out. However, right now they seem to be scheduling them for about a month from the date that you request it. Another important deadline that you should be aware of is that you must submit any mitigating information to the CRA within 2 weeks prior to the date of your compliance conference. That is really helpful to do because it gives the CRA analyst the opportunity to review everything before the compliance conference happens and will lead to a much more productive compliance conference if you are able to submit that mitigating information prior to the compliance conference. And they'll give you that 2-week deadline when they send you the calendar invite for the compliance conference. Where does the compliance conference happen? Well, nowadays, post-COVID, it happens over a video conferencing platform called Microsoft Teams. What will happen is the CRA analyst will send you a link to join that meeting in their calendar invite. I highly recommend trying to join the link about 15 minutes prior to the time of your compliance conference so that you can work out any kinks with connectivity. But it will be a video conference that the CRA participates in, that you dial into, and that your attorney can dial into as well. Why do the compliance conference instead of going right to the formal hearing? Well, the compliance conference really is an opportunity to try and resolve the formal complaint with the CRA without going through the added expense of the litigation process. As a result of the compliance conference, you could negotiate a resolution with the CRA that could be a consent order with a fine that hopefully you've convinced them to lower because of mitigating information you've presented at the compliance conference. Or sometimes the CRA will even withdraw the formal complaint if you've shown that the facts that they thought happened really didn't happen. Maybe there was some confusion on their end that you're able to clarify through the compliance conference process. So there really is a really good opportunity to try and resolve this without going through all the expense of the formal litigation in front of the ALJ. Now, if you aren't able to resolve the formal complaint through the compliance conference, then the formal hearing with the ALJ is always a next step that's an opportunity to try and resolve this. So that's the basic who, what, when, where, and why of a compliance conference in the cannabis industry. If you are a license holder who is facing a formal complaint and trying to decide if the compliance conference is the right process for you, feel free to give me or your cannabis counsel a call and we'll help you talk through the process and strategy for responding.